So in this policy, we're going to cover the purpose, the definitions that apply to this policy, specific prohibitions, a little bit about testing. So we'll talk a little bit about reporting for you supervisors, and we'll conclude with self-disclosure and consequences. So again, the purpose of this policy primarily is for your safety. We want you to be safe. We want you to be healthy. We want you to be accident-free. We want you to be as productive as you can with the agency. And we understand that inappropriate interactions with drug or alcohol can adversely affect all of those. We also have this policy to be in compliance with the Drug-Free Workplace Act of 1988, which is a federal law, kind of parallels the Executive Order 1990-2, which is our state's substance abuse policy that affects all state employees. So again, we're just a little more narrow or restrictive than that executive order. Definitions: prohibited substance includes illegal drugs, alcohol, or any controlled substance, in other words, a prescription drug, not taken in accordance with a legally obtained prescription or used inconsistently with a valid prescription that you've received. Reasonable suspicion is defined as any specific, articulable, and objective fact from which it is reasonable to infer that an employee has violated this policy. Here's the reason that our policy is a little more restrictive than the general state policy, and that is because we do pre-employment drug testing for all safety-sensitive positions. Doesn't necessarily affect any of us because we're not operative in the facilities, 5 facilities, the State Psychiatric Hospital in Evanston, the Life Resource Center in Lander, and then our 3 long-term care facilities with another one, 4th one, hopefully coming online sometime toward the end of the year. But anyone that delivers direct care to any of our vulnerable people, everyone that we provide care for in these facilities is vulnerable either from mental health or intellectual or brain function or by virtue of their age and perhaps frailness or health conditions. So we provide care 24 hours a day, 7 days a week for some very vulnerable people. And for that reason, we require pre-employment drug testing for those individuals. Under the influence is another way that we're a little more narrow than the state's policy, and that is defined as the use or misuse of any drug or controlled substance or alcohol that results in a positive drug or alcohol test. So we don't have a blood alcohol limit, for example, for alcohol usage. If we can detect alcohol in your system, then you're violating the policy. If we can detect marijuana in your system, then you're in violation of the policy, and along for the other host of drugs that were mentioned earlier. The workplace is defined as any state-owned or utilized premise for official state business, so we are all in the workplace at this moment. State-owned vehicles and personal vehicles which are being used to conduct state business. We're prohibited from being impaired in the workplace. We're prohibited from using, selling, dispensing, manufacturing, distributing, or possessing an illegal drug or drug paraphernalia in the workplace or away from the workplace if that action could have an adverse effect on work performance, the safety of other people, or puts at risk the reputation of the agency. I'm hoping that from the information that you've previously received during onboarding, you've kind of made this connection that the legislature is really, really important to us. Stated specifically, the legislature controls our funding and they controls the positions that are allocated to us. If we have a really strong reputation with the legislature, then when we make requests for increased funding or increased positions, we're likely to have a more favorable response to those requests. If our reputation has been weakened in any way, then that raises some concerns in the legislature. Well, we're not sure the Department of Health is necessarily trustworthy enough to provide additional funding or positions. So anything that our employees do that would be inappropriate or have the appearance of impropriety, if that gets back to the legislature, then that weakens our position. We've got a volunteer legislature. Most of their time throughout the year is spent with their constituents, and therefore they get to know pretty easily who the state employees are, who the Department of Health employees are in their communities. So the bottom line there is that we are being observed. Like it or not, as a state employee, people are aware of you and who you are and what you do. So the reputation comes into play there. We want to make sure that our employees do not put the reputation of the agency at risk. We're prohibited from having the presence of any detectable amount of prohibited substance in our bloodstreams while we're at work, while we're on the work premises, or the premises of customers. Our public health nurses go into their clients' homes and they do home visits, so that would be on the premises of the customers, essentially. Or we're prohibited from doing that while on assignment. So that may raise a question in your mind. You may think, gosh, I'm going to be going to a conference here in the next couple of months, and does that mean that I can't go into the hotel bar after the conference ends and have a drink at 6 o'clock or 7 o'clock at night? No, that doesn't mean that. When you are traveling for the state, you're representing the state, but only during the business hours of the time that whatever the business is that you're conducting for the state. We're prohibited from having any controlled substance in our system. So let's make an assumption there in that Elaine is skiing and she damages her knee and she goes to her physician, and the physician prescribes a muscle relaxant or a synthetic opioid to manage pain or something like that. What we would encourage Elaine to do would be to have a discussion with her physician and say, I work for the Department of Health, and she kind of explains her duties and then asks this key question. If I'm taking this prescription, how is this going to affect my behavior at work? So her physician or her pharmacist should be able to answer that question pretty specifically. With that answer, Elaine comes back to her supervisor and says, hey, I'm being treated by a physician and I'm under a prescription right now, and I may be acting a little differently in the next couple of weeks in these ways. She doesn't need to reveal what the injury was, who the physician is, or what the drug that she's taking. She can keep those issues private, but just to be transparent and above board and let her supervisor know that, hey, under this prescription I may be behaving a little differently while I'm taking it, gives him or her the alert that, well, if there are behavior change, there's a legitimate reason for that. We don't need to be suspicious of Elaine. If impairment is likely, if you don't feel like you can, perform your duties adequately, then take sick leave. And then, again, as the fourth bullet says, discuss with your supervisor the known side effects, perhaps how long you'll be taking the prescription, and any duties that may be inappropriate for you to perform during that time. So that's just some advice to kind of keep everything above the table and not below the table, and give your supervisor a kind of a heads up. All right, so for those of you that are supervisors, you may not permit an employee to remain on duty if you have an actual knowledge of the employee's possession of a prohibited substance. You must immediately contact the HR office if you are aware that they have a prohibited substance in the workplace. And you must not permit an employee to drive if you suspect them to be under the influence. In that situation, you would contact HR. We would make arrangements either for transportation to take them home, taxi, Uber, Lyft, whatever, or we would arrange for 2 employees to take that employee home, or we would call a family member and have them come and get that employee and take them home. The worst thing that we could do would be to put an impaired person behind the wheel and send them home and then we'd be liable for whatever damages happen in that situation. All right, I mentioned pre-employment testing. Anyone that's in a safety-sensitive position, we use breath or urinalysis. We also recently have changed our contract. We'll be using oral fluid testing in our various locations. If applicants fail to pass a test, or if they refuse to be tested, then they don't receive an offer for employment. And any tampering or adulteration of specimens would be considered a test refusal. Reasonable suspicion, for those of you that are supervisors, if you do suspect that someone that reports to you or someone that you work with is impaired, we would ask you to contact another supervisor, and the two of you independently review the behavior of that individual and document your notes. And then you'll get together and compare notes, and if there's an agreement that you both think that this person is impaired, at that point you would call HR and let us know. And then we would arrange for a drug test for that individual. Again, employees that that we have a reasonable suspicion that they're impaired, they will be subject to a drug test. The same conditions apply as for a pre-employment drug test. And a failure to pass or a refusal to test would result in disciplinary action, which could be up to and including termination. So triggers that supervisors that you might look for, certainly eyewitness evidence of unusual behavior, staggering, a lack of coordination, visible things like dilated pupils, constricted pupils, very rapid speech, certainly the presence of an odor of marijuana or alcohol on that individual. In combination with other things, an on-duty accident could be an indication, documented pattern of unsatisfactory work performance. All of those would be indicators that there may be a reason for a drug test. An arrest or conviction of a drug-related offense would certainly result in a drug test and any newly discovered evidence of tampering. If we suspect alcohol is the cause of impairment, then we would either use a breath sample or an oral fluid sample. If the suspected drug is something other than alcohol, then a urine sample or an oral fluid sample. And then we contract with several providers who provide drug testing services for us, and each of them have a medical review officer. This is a licensed physician. They review the results of the drug test that come from the laboratory, and they will contact the donor of that specimen and ask for evidence of a prescription that would justify the presence of that drug in their system. And if the suspected employee cannot provide that prescription, then it's considered a positive drug test. Just for your confidence, employee drug tests are not performed by the public health laboratory, even though they're fully equipped to do that for confidentiality and other reasons. We send all of our drug tests out again through these third-party providers that send them to other laboratories. All right, for you supervisors then, you are required to report to the HR office any evidence leading to reasonable suspicion. So documenting those observations is critically important. We need you to do that and keep those in some kind of a private locked cabinet or drawer. We would like you to read the substance abuse policy. A link to that policy is on the onboarding schedule. We'd like you to become familiar with that, read that, and everyone else is welcome to read the policy as well. And then if you violate the responsibilities in this policy, then that would result in some form of disciplinary action. We do want you to know that if you are suffering from a dependency or an addiction on any kind of substance, there is no penalty for self-disclosure. We encourage you to self-disclose. There are lots of resources that we can bring to bear as an agency to help you in recovering from that dependency or that addiction, and we would really be happy to help you do that. We want to keep you as a productive employee. So, if this is in the background and it is bothersome to you and you're struggling with it, then we encourage you to bring it forward and let us provide resources to you to help. Consequences. If applicants fail to pass a drug or alcohol test, then they don't get to work with us. For all other employees, for reasonable suspicion tests, then there will be disciplinary action that eventually could go up to dismissal. We would encourage you to participate in the Employee Assistance Program, which we could instruct you to seek medical assistance. And then just as a note to the family medical leave policy, any absence for treatment is under job protected leave. You could claim that as family medical leave for job protection purposes. FMLA is not available for absences due to usage. So if you get way hungover and you can't come to work on a Monday because you've been drinking over the weekend, that's not available for family medical leave. Following a positive drug test, then employees will be required at their own expense to submit to a minimum of 3 unannounced drug or alcohol tests within the following 12 months. If there's an additional positive drug test during that time, then they'll be recommended for dismissal. And if an employee is arrested for a criminal drug or alcohol violation, they're obligated to notify their supervisor within 24 hours. So that is the substance abuse policy. This concludes the Wyoming Department of Health presentation on drug and alcohol policy. If you have any questions, please contact your human resources representative or send an email to wdhr@wyo.gov. Thank you for watching this presentation to the end.